Thank you for joining us for day 3 of the Denton's Ontario Employment and Labor Spring Webinar Series. I'm Andy Pushlik, a partner in the Toronto office and the practice group lead for our Labor and Employment group. I'm very hopeful that this is very much an example of save the best for last. I will be presenting today along with my colleagues Kyle Isherwood, Stephanie Chimenti, and Kate Brower. We're going to start the presentation today with Kyle and I talking about some case law updates for the area of wrongful dismissals and issues largely stemming from COVID, but hopefully there'll be some principles that you're going to be able to apply in a post-COVID world. Next, Stephanie Chimenti will be outlining the process for appealing a WSIB decision. WSIB has always been part of the employment life cycle in terms of having to deal with that body, but it can be difficult for our clients to navigate. So I know that you'll really enjoy Stephanie's how to approach and how to deal with the WSIB. And last but not least, we're very grateful to have Kate Brower, who's a partner in our Toronto office and the Global Client Development and Women's Client and Markets initiative. She is one of our foremost experts on diversity and inclusion. And I think we all appreciate that diversity and inclusion has always been an important feature of any progressive HR department. However, it's taking on certainly a much more greater importance in the workplace. And so Kate will talk to you about how best to position your organization to deliver greater equity, inclusion, and diversity. We'll have some information at the end of the presentation, just reminding you to subscribe to our blog and podcast for the latest updates. There is going to be some client alerts going out in the next few days, as there have been more and more cases that have been decided by the Ontario Superior Court, and in this case, the Ontario Divisional Court, an important decision on severance pay that we think you're going to want to know about. You can find information about that on our website. And like I said, there will be information as well at the end of this presentation, but also as part of our follow-up email with the materials. With that, we'll kick it off with an update on wrongful dismissal case law with a focus in Ontario, although we have been able to cherry pick a few cases from BC that are favorable for employers. So where are things at? When we were talking about COVID-19 a year ago, people were very, very concerned as to how judges would look at the pandemic and its impact on the economy in deciding notice. As you know, reasonable notice is not science, it's not a mathematical equation. There is a bit of art to it. We look at a variety of factors, and one of those factors that judges will pay attention to are the prevailing economic conditions. And what the case law has indicated now, and I'm willing to say that the bump has not been anything material. If there's been any sort of increase in notice periods, and you know, this is probably anecdotal, it's been marginal. And what a key kind of principle coming from the case law is that reasonable notice is to be assessed at the time the termination decision is made. And what we've included as we look at the next couple of slides are some quotes from cases that have been decided recently on the issue of notice and how judges are dealing with. So if you go to the next slide, we have a quote from the Ontario Superior Court in Yee and Hudson Bay's company. And this was one of the early decisions. And I know for some of our regular viewers, they will have heard either my colleagues Alison Buchanan or another colleague talk about this case. And what the judge said on the COVID-19 bump is that it seems clear terminations which occurred before the COVID pandemic and its effect on employment opportunities should not attract the same consideration as termination after the beginning of the COVID pandemic and its negative effect on finding comparable employment. So at that point, back in December of 2020, we'd already been through about 9 months of the pandemic. Cases were now just starting to get through the courts. The judges were signaling that pre-pandemic, you weren't going to get a bump just because you happened to be in the middle of your notice period. And if we go to the next case, which was decided a month later, another Ontario Superior Court of Justice case, this is a Peninsula Employment Services Limited. This is a very helpful quote, and I think it really encapsulates what we're looking at from a notice analysis where employees have been dismissed during the pandemic. And what's most helpful here is the judge says there's no doubt that the pandemic has had some effect on this employee's job search, and it would have been reasonably expected to do so at the time his employment was terminated in late March 2020. So right at the beginning when the pandemic was really setting in. But the judge goes on and says, however, it must also be borne in mind that the impact of the pandemic on the economy in general and on the job market in particular was highly speculative and uncertain both as to degree and to duration at the time Mr. Iroquois' employment was terminated. The principle of reasonable notice is not a guaranteed bridge to alternative employment in all cases, however long it may take, even if an assessment of the time reasonably anticipated to be necessary to secure alternative employment is a significant factor in its determination. And the judge then concludes by saying, I must be alert to the dangers of applying hindsight to the measuring of reasonable notice at the time when the decision was made to part ways with the plaintiff. So what the judges have said and what the case law seems to be kind of bearing out is that it was so unclear back in March what was happening with the economy that it's very difficult to say that there was an automatic COVID-19 bump. Here, the judge is at least acknowledging that yes, there could have been some impact, but at the same time, and I think this has been clear by people's experience, this has been an uneven pandemic in terms of its economic impact. If you were an employer who was in warehousing or distribution, your economic situation is obviously far different than someone who was owning a restaurant. And if you were permitted to operate and you were declared an essential business, probably different than if you were in the travel industry. And so it's going to be a nuanced approach that judges are going to take. And I'm hopeful that as we now are into this new phase and hopefully final phase where the economy is opening up, we're not going to see these drastic changes in how we assess notice, that employees are going to be able to get a much more significant period of reasonable notice on the back end. I think what's important is the system is set up at its base to be fair. We want to ensure that employees have a cushion to transition to new employment. And we also want to respect that employees and employers have a freedom to contract and can limit that through a negotiated employment termination clause in an employment contract. So where are we? As I end this first section, if we look to the next slide, what we've included is this shows the unemployment rate in Canada from about 2017 to present. And if you look at that spike is a year ago in May. So the May unemployment rate was the highest on record in Canada. It was 13.7%. Last month, it was reported to be 8.2%. So you can see a dramatic increase in terms of employment of Canadians. And if you want to know where things were before the pandemic set in, January is probably one of the last true measures of where we were at. As we got into February and certainly March, people were getting a bit more anxious. The unemployment rate at January 2020 was 5.5%. So we're getting much closer to pre-pandemic unemployment. And so that leads me to say, I don't think you're going to see a COVID-19 bump in the case law for very much longer. And if there is one, like I said, our view of the case law, or at least my view of what the cases that have been decided, it hasn't been anything material. So I think that we are able to assess notice on the traditional factors that we've done, in the many years before we had the COVID-19 pandemic. And I'm hopeful as well that if the employment rate really starts to drop, you're going to see a real increase in people being able to secure jobs quickly. With that, I'm going to pass it over to Kyle, and he's going to talk to you about some of the mitigation case law involving the Canada Emergency Response Benefit.
Thanks, Andy. So the first case that we're going to talk about here more in depth discusses whether the CERB, the Canada Emergency Response Benefit, is deductible from damages as a result of a wrongful dismissal claim. This is a recent BC Supreme Court decision, Hogan versus a number company in BC. The number company operated a car dealership. In this case, the employee was laid off and subsequently terminated, so he wasn't recalled. He sued for constructive dismissal, and his claim was successful, and he was awarded 22 months of notice. There's an interesting discussion in in the case law about the employee's obligation to return to the office as part of his duty to mitigate because the employer had offered him a job. However, this was ultimately rejected for a number of reasons. Turning to damages, the court stated the long-held goal that the goal of damages is to put the employee in the same economic position they would have been had reasonable notice been given. And then they kind of go into a discussion on benefits and benefits after termination. So when discussing benefits that result in compensation to the employee after benefits, they have to consider whether the benefit would not have been received but for the employee's termination. Generally, benefits that are received from private insurance are not deducted from damage awards. And where they are deducted, it's usually because they're intended to be a sort of indemnity for the type of loss suffered as a result of the termination. Turning to the CERB, it's clear the CERB would not have been received if it wasn't for the breach, or sorry, if it wasn't for the termination of the employee's employment. The court then went on to distinguish CERB benefits from those of employment insurance because neither employee nor the employer contributed to those benefits. There's also no evidence that the plaintiff would have had to repay the CERB if they were paid out any amount due to wrongful dismissal. So ultimately, if the employee received their benefits under the CERB and then also received a wrongful dismissal claim, they would actually end up, as the judge concluded, in a better economic position than they would have been otherwise. They'd have both their wrongful dismissal damages for 22 months plus the benefits they've received for CERB. As a result, the judge, or CERB or CERB, as a result, the judge deducted the CERB benefits that the employee received during the notice period from the amount of damages awarded to the employee. At this point, I just want to note that the judge in this case distinguished from Ontario case law, which had found kind of the opposite, that CERB amounts were not to be deducted for wrongful dismissal. The judge in this case distinguished from that one in Ontario by saying that in the Ontario case, the plaintiff would not have been in a better position because of the way that the contract in that case was drafted. And therefore, in this case, because the employee would receive full 22 months of notice and the CERB benefit, that they would end up in a better position than they would have otherwise. And with that, I'll pass it back on to Andy.
Great, thanks, Kyle. So the last case we wanted to talk about, again, on this issue of mitigation, as I said at the outset, there doesn't seem to have been a material bump in wrongful dismissal notice periods due to COVID-19. So the next logical question was, were judges being more sympathetic or willing to overlook an employee's failure to mitigate on the assumption that the pandemic was so widespread in its economic damage that it would have been impossible for an employee to find new employment? And a very recent case, another case out of BC, shows that there is some good news for employers in the mitigation area of case law. So in this case, you had a 53-year-old salesperson, 27 years of service, dismissed in July 2020. So again, right in the middle of the pandemic. And what this employer had done is they had identified a list of postings that it argued would have been reasonable for the employee to pursue. The employee did not pursue any of these jobs. And in fact, what the employee did was looking to kind of stay in the exact same industry as a salesperson versus being a salesperson in any other industry. So the judge awarded a notice period of 20 months, but actually reduced the notice period by 3 months due to the employee's failure to mitigate his losses. And there's really helpful language in the decision. If you go to the next slide, we've put that the quotes that are probably most applicable to employers going forward. So if you look at the next slide, a job search in COVID times must necessarily look different. Physically knocking on doors or invitations to lunch are not reasonable job search expectations during COVID time. Mr. Moore nonetheless has an obligation to take active steps to search for reasonably similar employment. This could include phone calls, cover letters, emails, use of a headhunting employment search service, or otherwise reaching out and connecting with potential employers. I find that reasonableness in the circumstances required Mr. Moore to cast a net further than the very limited pool of commercial tire sales and take steps beyond his limited efforts. And then the judge goes on to talk about what an active job search will look like, and what's really helpful here is the second line there, looking at job postings absent further action is not sufficient to fulfill the requirement that a person undertake a reasonable job search. A reasonable job search may include activities such as reaching out to contacts within the industry, writing cover letters, setting out why you qualify for a position, following up with telephone calls or email correspondence. When we're litigating wrongful dismissal cases, the onus on employers to be able to succeed on a failure to mitigate is very high. And it's not sufficient just to say that the employee didn't look hard enough to get a job. The second piece, and that's where you really have to be diligent, is you have to be able to demonstrate to a judge that had the employee looked, had the employee done all of the things that the judge is talking about on this slide, they would have found replacement employment that was reasonable. And the way you do that is by collecting job opportunities during the period and sending them to the employee. And I know it sounds like a real added administrative burden on your HR group or whoever you're going to task with this. And the reason why it sounds like that is it is, but it can really reap benefits. You see in this case, a 26-year employee getting 20 months and then getting that reduced by 3 months to 17. To me, that's worth the effort in trying to come up with a system where you're getting the job opportunities out to this employee. And far and apart from just the legal principles associated with it, it's good practice to try and help former employees where we can to limit or mitigate the effects of being dislocated from the workforce. So if you can help in any way and by getting those job opportunities out to the person, hopefully that person will find reasonable employment through it, and that's going to reduce your damages. It's going to be a win-win for everyone, but it will take some time and it will take some effort. So that's where things are at right now from a COVID standpoint. One case I haven't referenced, but for those of you who are on our mailing list, you're going to be receiving a client alert later on today. The Ontario Divisional Court this week issued an important decision on the interpretation of statutory severance pay. For those of you on the call, you'll know that in Ontario, we have, in addition to notice pay, the 1 week for every week of every year of service to a maximum of 8, we also have the concept of severance pay, which is only applicable to employees who have accumulated 5 years of service, and the employer has a payroll of $2.5 million. There are some other qualifications for the end of operations, but the most common is the 5 years of service plus the payroll of $2.5 million. What the court said this week is that payroll calculation is not limited to an Ontario payroll. There have been some mixed case law. I think we were hoping as Employers Council that had been settled, that it was Ontario only, but the court has now said that it's global. And so what that means and why that's significant is if you are a very small part of a larger global company and you do not have a payroll in Ontario of over $2.5 million, but when you combine it with your global payroll, you are now going to have to be paying your employees severance pay. And like I said, we have a detailed case note coming out today. So do watch for that. And if you have any questions, please reach out to your regular Denton's labor and employment lawyer. So with that, a bit of good news. I'll pass it on to Stephanie, who is going to talk to you about appealing WSIB decisions.
Thanks so much, Andy. Good afternoon, everyone. I'm very happy to be here this afternoon to speak to you about the steps to appealing a WSIB decision. Next slide, please. I thought I would kick off my presentation just by highlighting the most common types of benefits claimed at the WSIB. So these statistics are published by the WSIB. And as you'll see on the slide, loss of earnings benefits and healthcare benefits continue to be the most commonly claimed benefits at the board. So loss of earning benefits are awarded if there's been lost time as a result of a workplace injury. And of course, healthcare benefits help with a worker recover from his or her injury by providing, for example, prescription drug benefits or medical equipment and supplies and so on. Other types of claims that you see are for future economic loss. So for example, if the worker has a longer term injury, they may be entitled to this benefit, or a non-economic loss benefit, which is normally awarded if there's a finding of a permanent ongoing impairment. I know that the WSIB has a continued focus on high impact claims, those being injuries to the lower back, shoulders, or fractures. And that's typically because those types of injuries require a longer recovery time and they have higher treatment costs, therefore resulting in higher benefit awards at the board. Claims that you do not see on the slide, but also may come across your desk is workers' reemployment and return to work plans. So I hope this first slide provides you with some sort of insight into what you may see come across your desk. Next slide, please. So if you do see a claim for benefits come across your desk and it's in the favor of the worker, you may consider the decision and think, well, why should I object to this decision? And there may be a number of different reasons why you wish to do so. For example, you don't believe that the worker is as injured as they say they are, or the workplace injury cannot be causally linked, or in your view is not related to the workplace. Or for example, the action of the employee simply takes that employee out of the scope of employment. Or frankly, it could be a cost reason. So what is the cost to the benefit as a result of the successful claim for benefits by this worker? How does this claim for benefits affect my projected premium ratings with the board? So it's definitely worth, when you have a decision come across your desk, to take a look at it and do an internal assessment as to what the cost is going to be and whether it's worth to proceed with an objection. Next slide, please. So I do know that my presentation today is solely focused on employers commencing an appeal with the WSIB and what an employer must do to commence that appeal. For this reason, I will not be addressing timelines and forms for an employer to participate in an appeal commenced by a worker, as there are different requirements for that. I also note that this presentation does not address appeals for employer account objections, as there are more nuanced rules related to those types of objections. So both the worker and the employer have a right to appeal a decision made by the WSIB. So as a starting point, I note that WSIB decisions are first made by case managers. So it's the case manager's decisions that you will normally be appealing if you so choose to proceed with an appeal. And if you do appeal a claims adjudicator case manager's decision, the appeal will go to the WSIB Appeals Services Division. So this is the first level of appeal, and it is internal to the WSIB. And this is where final decisions of WSIB claims are made. Employers who disagree with decisions made by the Appeal Services Division at the WSIB can then appeal to the Workplace Safety and Insurance Appeals Tribunal. And the tribunal is external to and independent of the WSIB. And I'll be speaking briefly about the tribunal later on in my presentation. I should note that it's also, if I didn't say it already, the second and final level of appeal is the tribunal. So time limits to object. So if you receive a WSIB decision, it is important to note any time limit that you're up against in the case. So you do have 30 days to object to a WSIB decision if it's related to return to work or reemployment. You have 6 months to object to any other WSIB decision. So it's important not to miss these deadlines because the WSIB is not obligated to grant you an extension if you seek one. Next slide, please. So persons involved in your WSIB appeal, if you're new to this process, there's a number of parties involved, which may be unclear as to what role each party plays. So I thought I would just set out who is who in this slide. So you as the employer objecting to a decision are the objecting party. The appeals resolution officer is responsible for resolving all appeals at the WSIB and is the final decision maker at the WSIB. The appeals registrar is your main contact during the appeals process and handles such things as requests to add issues to an appeal, making time limit decisions, and the sharing of healthcare information, and so on. The appeals coordinator handles the administrative aspects of the appeal, so things like scheduling, summonses, contact witnesses for the witnesses, pre-hearing issues, and is responsible for assigning the case to an appeals resolution officer. And of course, the worker is involved in the appeal, as it is, of course, the worker's claim for benefits, and any witnesses called by you, the employer, or a worker will be involved at the hearing stage. Next slide, please. So if you disagree with a claims decision, this is where I'll be discussing what steps you need to take to appeal that decision. So step 1 is complete and file the intent to object form, with the WSIB. And in this form, you can provide your reasons for your objection and any new evidence that you may have and that you intend to rely on at the appeal. So that said, these forms are generally kept quite short. It requires such things as the worker's name and claim number, the employer's information, the employer's representative, if you were using a representative at the hearing, the date of the decisions, and of course the issues in dispute. This form can also be used to set out any new information or an additional explanation that might change the decision. So it's an important form and it's a needed form to use to bookmark your objection, and it may be an early opportunity to provide new information that might change that decision. So upon receipt of the intent to object form, the WSIB or the original decision maker may reconsider that decision and render maybe perhaps a new decision based on the information that you've provided in the intent to object form. If the decision does not change, then the appeal will move forward in the appeal process. So at that point, step 2 is you await for the claim file and appeal readiness form if the decision remains unchanged. And the appeal readiness form lets the board know that you're ready to proceed with your appeal and that you want to start a formal appeal with the board. There is no time limit to filing or submitting this appeal readiness form with the board. And that's because the board really wants parties to be ready and prepared to move forward with their appeal. And so they provide you with the time to do so. So step 3, once you are ready to proceed with your appeal, you complete and return the appeal readiness form with the board. So after you've considered the entire claim file and once you are ready to proceed, you can submit this form, but only submit your form when you're ready to proceed, meaning that you have all the evidence that you need for your case, whether that be if you're obtaining an external expert opinion or any other evidence that you have to go forward with the appeals process. This is an important point since you cannot later on add new issues to the appeal or new evidence once you file this appeal readiness form, unless there are exceptional circumstances. And also when you're submitting this form, you should be prepared to attend at a hearing within 90 days. That said, I do know that the WSIB, upon filing this form, is booking hearings about 4 to 6 months out, I would say, but nonetheless, you need to be prepared to attend at a hearing within 90 days, and you are required to provide an attestation that you are able and ready to do so. So included in this appeals readiness form, you must also address the names of any witnesses, including a brief summary of their evidence. If you're requesting an appeal in writing, this is also where you need to set out your submissions, as there will be no further opportunity to argue the merits of the case, and the case and claim in your appeals readiness form will just go directly to an appeals resolution officer for a decision. And of course, once you file this form, the non-objecting party, so the worker here, will be notified that you are ready to proceed with your appeal. Next slide, please. Thank you. So types of hearings. So when you're completing the appeal readiness form, as I said, you're going to indicate whether you want to proceed by oral or written hearing. So a hearing will normally proceed in writing at the board if it's mostly based on medical evidence or law or policy, and if the credibility of the worker is not in dispute. So if the case is being heard in writing, the ARO will rely on the claim file, the respondent form filed by the non-objecting party, and your appeals readiness form to make a decision. If the hearing is proceeding orally, the WSIB will call the parties in advance to arrange a date and time for the hearing, and it may be done in person, but of course during COVID-19, it will be proceeding by video or teleconference. At the oral hearing itself, the ARO will be there to hear the evidence from both parties, including any witness evidence, and there will be an opportunity to make closing submissions with the ARO. That said, this process with the WSIB is much more informal than you would find in the courts, but it's still, the hearing is still completed in a structured format. Next slide, please. So once the hearing in writing or the written hearing has concluded, the ARO will issue a decision, which I again note is the final decision of the WSIB. This decision will be written in an anonymized style and will of course set out the appeals resolutions officer's findings and conclusion reached, including the reasons and the evidence she or he considered and the weight of that evidence. A copy of the decision will of course be sent to both parties and filed within the claim file. Next slide, please. So if you then have the decision from the appeals resolution officer and it comes back and you think, oh, this is an unclear decision, or it's an incomplete decision, or there's an obvious error, then you can then write to the ARO in writing with full particulars of your reason for the request for clarification, and you can request a clarification. The ARO will then issue an addendum decision to clarify that decision or complete an otherwise incomplete decision. Next slide, please. You can also request a reconsideration of that decision. So if you think the ARO should reconsider their decision, you must again submit this request in writing and be as detailed and comprehensive as you can for the reasons you're requesting the reconsideration. This is not an opportunity to re-argue your appeal, but rather a request for reconsideration may include reasons such as a substantive defect in the decision made by the appeals resolution officer, a failure to properly apply the act or the policy, or significant new evidence that did not exist at the time the ARO made their decision. So a request for reconsideration should be made to the ARO as soon as possible, and at the very latest before the 2-year mark. And again, very important deadlines that you need to keep in mind. And if there are grounds to warrant a reconsideration, the WSIB may reconsider that decision and whether the decision should be changed in a substantive way. And of course, again, the WSIB will notify all workplace parties of the outcome of that reconsideration decision. Next slide, please. So there are also de novo decisions at the WSIB, and de novo in general terms means a new decision or de novo starting fresh from the beginning. And this is where, for example, there's been a significant procedural flaw that makes the appeal process fundamentally unfair. And in that case, the WSIB will consider the decision voidable. So an example of this would be, for example, an employer or a worker files an employer participant form to participate in the appeal, but they were mistakenly excluded from that appeals process. And if this happens, the WSIB will conduct a new hearing and have a new decision rendered by a second ARO and not the original decision maker. So to conclude my presentation, once you have a final WSIB decision rendered from an ARO, and if you still disagree with that final WSIB decision, you can appeal it to the Workplace Safety and Insurance Appeals Tribunal, which I mentioned earlier. And again, this is an external body to the WSIB, and it is the final level of appeal. And quite frankly, the topic of the tribunal is could have its very own presentation. So I'm going to, for the purpose of today, be mindful of the time and just kind of hit the highlights, which is the WSIB will of course notify you when they provide you with the appeals resolution officer's decision, the final decision of the WSIB, of the requisite timeline to file an appeal with the tribunal. So you will be told that date, and it's 6 months from the date of the final WSIB decision that you have to appeal it to the tribunal. And with that, I will conclude my presentation and now pass it along to Kate Brower for her topic on inclusion, diversity, and equity in the workplace.
Thank you so much, Stephanie, and great to be with all of you today. I'm going to take the conversation maybe up about 30,000 feet as we have this discussion around inclusion and diversity and positioning your organization for success. I think it would be fair to say that it is an understatement to describe the last 12 to 18 months as a very busy time in equity, inclusion, and diversity. The pressure is increasing on everyone to do more and deliver more. Governments are feeling it, organizations are feeling it, and individuals are feeling it. Some companies and organizations have had more of a head start than others, but feeling a need to up our game is almost universal. And to get the job done, we are seeing companies turn to two key functions, talent and HR, which is probably obvious place to look to most of us, but also increasingly the legal function or the general counsel's office. This isn't to say that there isn't an impact from inclusion and diversity across multiple functions in an organization, but when we are seeing groups that are being asked to take on and lead the effort, most often we're seeing that in talent or HR and increasingly in our general counsel's offices. Next slide, please. So I think as we dive into the conversation, it's really important to think about the key stakeholder groups that we're trying to, or that we're dealing with, and the drivers of what companies need to deliver. And when we start to do that, there's lots to think about. Of course, people are at the heart of the discussion because that is where we are trying to deliver greater equity, diversity, and inclusion. But the forces that are driving greater action are both internal and external. And if you look on the left-hand side of the screen, some of the external drivers we're seeing are in the form of increased expectations and demands from shareholders, investors, and customers, as well as regulators. And on regulatory side, you can think about things like board diversity requirements. You can think about things like human rights obligations, and so on. On the right-hand side, you're seeing some of our internal stakeholder groups that are impacted. Our boards are impacted, executive teams are paying more attention, leaders throughout organizations are paying more attention, or they need to. And these are the key groups that are being asked to deliver. Then when we start to think about why organizations are turning to their talent and HR functions and increasingly their legal functions, to execute, it starts to make a lot more sense. Again, while the important role talent plays is obvious to all, the role legal can and does play may be a little more nuanced for some and could go well beyond ensuring that programs and policies that are in place in the talent space are legally compliant. Those are the things that we might typically think about. But then again, as we start to look more broadly and take that broader view, and we're seeing increased regulatory scrutiny, the evolving discussions around ESG, where external stakeholders are taking a keen interest in an organization's inclusion and diversity hygiene, issues like reputational risk, conduct and ethics start to arise, and the role and the extent of the legal function in the conversation starts to become increasingly clear. Now, before we go further, I just want to turn to the next slide and do some stage setting and talk about some definitions. So I think it's really important to note, and it's something that we see is a common struggle and challenge, is that the lexicon of inclusion, equity, and diversity is extensive, it can be complicated, and it's constantly evolving. So much so, in fact, that it is well understood that the language itself can often be a barrier to advancing inclusion and diversity conversations. So I wanted to just dive in with some really basic concepts so that we could, all agree on what we're talking about, but really highlight and put a big note around the fact that it's important to be conscious of language and the lexicon. And of course, this is by no means an exhaustive list. So let's start with the concept of representation. And I think it's really important to think about that concept as distinctive from diversity. These two often get mixed up. So representation really truly is the how many. This is the very basic and straightforward exercise of looking at the demographic makeup of our people. Think census here. Diversity, on the other hand, describes the combination of characteristics that make up each of us and make each of us unique. It's the what rather than the how many. And to be clear, and particularly in the Canadian context, diversity, and in the Canadian lexicon, diversity includes majority group. So diversity would include, in the Canada context, a straight, white, able-bodied man who's often held out as, as the predominant majority group member. You will often hear in other contexts that people talk about diverse people to mean someone who does not fit that description. That is not typically how we would talk about it in Canada. Again, diversity includes everyone. Where that straight, white, able-bodied male group, that is the majority group in business for the most part, would not fit, however, is in if we look 2 down, the underrepresented or the equity-seeking group category. That's another really important term for us to understand. And an underrepresented or equity-seeking group is precisely that. These are the groups of people for whom we are working to deliver greater equality. If we go look in the middle of the slide, we see inclusion, again, another word that we hear a lot. At Dentons, we talk about inclusion as making diversity count. These are all the actions that we take to ensure that all of our people with all the diverse backgrounds and unique characteristics that inform who they are feel included and can contribute in the environment. And a quick note, I think, importantly, to talk about equity versus equality. This is also a confusing distinction, and people can mix these up from time to time. And, you know, to simplify it, think about equality as the ultimate objective and equity as a means to get there. So equity recognizes that different circumstances require different allocations of resources to yield equal outcomes. A great example might be 2 young people seeking a university education, but coming from different financial means. A scholarship program that takes into account financial need as well as marks includes an equity component. What it's aiming to do is look at that different financial circumstance where 2 individuals have the same marks in order to yield an equal outcome by facilitating that university admission. The final one on this slide, again, these are 6 basic concepts out of many, many concepts, is the concept of allyship or allies. People will have heard about this. It's certainly being talked about. Many of your organizations will have allies programs. We spend a lot of time at Dentons talking about this concept as well, because it focuses on the shared responsibility of everyone to advance greater equity, diversity, and inclusion. And allyship is not just for the majority group, it's for everyone. That's how we approach it. And our definition of an ally is a member of a social group that enjoys some privilege and works to end the marginalization of others through self-education and action-oriented support. Now, just to be clear, marginalized people or groups or marginalization is the process by which individuals or groups are excluded from full participation in social, economic, and political life. Just as a quick example around allyship or what it means to be an ally, while I might be part of a marginalized group, a traditionally marginalized group because of my gender, the fact that I am white allows me to be an ally, and it grants me a privilege that allows me to be an ally to people from racialized minority groups, for example. So that's a lot of background. If we go to the next slide, we can start to talk a little bit about what does this mean and how do you go about building an effective strategy in the current context. Well, depending on the structure of your organization, if you're a person or group that has been asked to deliver on the equity, inclusion, and diversity agenda, it can be a daunting task, as there's a lot to think about, and we've already talked about some of those things, and many, many stakeholder interests to juggle. Some will have access to inclusion, equity, and diversity experts in-house, and others may not. I think it's very important to recognize and acknowledge that, in fact, inclusion and diversity is a specialized discipline and area of expertise, and frequently, and with no ill intention, but commonly mistakes can be made by simply adding inclusion and diversity to the talent or HR functions responsibility and not providing as much access as might be needed to inclusion and diversity expertise. And another common mistake that we see, albeit again a very well-intentioned one, is to assemble a group of employees from underrepresented or marginalized groups and then task them with the responsibility for advancing inclusion and diversity in the organization. Again, this is often done with the best of intentions and is seen as a means of empowering groups that may have felt excluded and without a voice. And while it is extremely important that these groups can and must play a role, they create networks, they're safe spaces, for people to come together in a robust inclusion and diversity effort, responsibility for advancing the overall agenda should always lie with the organization. Doing it the other way can put undue pressure on that group that we're trying to empower and create more work and stress, and oftentimes, unfortunately, it's unpaid work. So positioning the effort for greatest success requires a well thought out and intentional approach. As you know, the best approaches will treat inclusion and diversity like any other business imperative. And as you start to build out that strategy, whether it's new or refreshed, you'll want to think about a few things. First of all, taking stock of where you are. It's important to have a baseline understanding of where you are in order to know where you want to go. Understanding your demographic makeup is key. Remember representation we just talked about, and a great starting point. But you might also want to consider embedding diversity data into your engagement surveying to start looking at engagement data through a diversity lens. This type of information can be invaluable in helping you develop and deliver meaningful initiatives that will actually move the numbers. Yes, all of this can be done in a legally compliant way in line with privacy and human rights requirements. Some of you may be thinking about that. You can measure, you can ask people for information about their background, their ethnicity, LGBT status, and so on. Again, there are ways to go about it, and of course, we can always help with that. Then it's really important to engage with your people and your stakeholders. A consultation process around issues, aspirations, and expectations is critical to make sure you're aiming in the right direction. This can be delicate and difficult, but it is essential. And again, this is a place where calling upon people with inclusion and diversity expertise might be a really good idea. Again, like any other business imperative, define your goals and objectives. Best recommendation here is don't boil the ocean. Think about short, medium, and long-term goals. What matters in your industry? What are the pressure points? Maybe you're working in a STEM industry with fewer women in a candidate pool for some roles, or in the banking sector, and you might have challenges with representation of some groups in your capital markets team. These are very common scenarios. As you take stock, then you can help figure out what your goals and objectives should be. Make sure they are realistic, and think creatively about what you want to achieve and how you want to measure progress. It doesn't always have to be strictly in numbers. You could think about measuring experience. How is one group experiencing life in the organization versus another? Remember what I said about looking at your engagement survey through a diversity lens. Then it's execute, execute, execute. It's difficult to do inclusion and diversity off the side of the desk. It's important to build it into your processes and system. Ask a lot of whys. Look at a career life cycle, all of the places where there are challenges in representation, and then keep asking why. Why don't we have greater representation of people with disabilities? Why are women and racialized minority people leaving the organization in greater numbers? Why are LGBT plus identified people not advancing into leadership roles, and so on? Effective inclusion and diversity strategies demand a disaggregation of processes and then a focused effort to change those processes to meet goals. And then measure again. Absolutely critical. Measure, measure, measure. As we say, rinse and repeat. It will take you right back to the beginning of your taking stock, and then you can build your next pillar of the strategy. And with that, I think I'm at time.
We do have a couple questions, and Kate, while you're spotlighted, I will start with you. And you talked about goals being set, small, medium, long, and there's a lot of really good information. But can you give an example of what you've been seeing clients, or what is a goal? Because I think a lot of times when we're in management meetings or when we're talking to clients, everyone says, we want to do better. We want to ensure that we are advancing diversity and inclusion, but what does that look like? Like what should be a concrete or an example of a concrete goal that people can work towards beyond just saying, as you say, boil the ocean and we'll all just be better?
Right. So I think there are a couple of important pieces there, Andy. The first is ultimately we do want to look at the numbers, right? We do want to look at the representation of different groups in our organization in different roles at different levels and so on. The challenge I think that organizations have is that can take a long time. It can take a long time to shift the numbers in many cases, but we can't ignore the numbers. So what do you do in the interim? Well, you can set interim goals. So, you might set a target for an increase in a certain demographic group. But one of the things that I really like and I find really effective is to think differently about how we measure. So one of the mistakes organizations frequently make is they set really ambitious, terrific numerical goals, but don't spend as much time as they should perhaps thinking about how they're going to get there. So how are we going to get, and I'll use an example, how are we going to get women into leadership positions? Well, one of the things that we know is really important is people need to believe that they can succeed in their organization and advance in their organization in order to stick it out, right? To make it into and to try for those positions. Well, one of the things you can measure is ask about experience. How do you feel? You can, ask this of all your people. How do you feel about your opportunities to succeed in the organization? Ask that question of everybody and then look at it through a gender lens. And is there now a gap between how women are feeling about that and men are feeling about that in your organization? And then what you can do is start to think, okay, well, maybe women are not staying or advancing because they don't actually think they're going to succeed. So then what you can start to do is start to try to even that balance and close that gap. And then that in turn will push your numbers. So it's looking at it really through the whole cycle of what it takes to get to that ultimate goal. But to be clear, you need those ultimate goals. I'm convinced of that. You have to have a target that you're aiming for.
Great. Thanks, Kate. I think that's very helpful. Stephanie, question for you about WSIB and this phrasing downside risk. What does that mean when the WSIB is using that? It does not sound good.
No, that's a good question, Andy. Thank you. Sometimes when the ARO reviews a claim file, they find a significant error in the case manager's decision. So for example, if an employer is appealing a non-economic loss decision and arguing that this worker is not entitled to this type of benefit or to a lesser NEL benefit award, but the ARO finds actually this worker should be entitled to a higher award, then that's what's called the downside risk. So if the ARO finds an error like this in your appeal, they will let you, the objecting party, know, and you can decide at that point whether you wish to proceed with your appeal or discontinue it or withdraw your appeal. And if you do continue with your appeal, then you accept that downside risk is a possibility.
Great, thanks, Stephanie. Kate, back to you, probably our last question of the day. A question about how or what you should do if you're looking at if you're a smaller organization, what kinds of things you can do to advance diversity and inclusion?
I don't know. I mean, small could mean any size, but I don't think the recipe is that different for small organizations and larger organizations. I think there's some key ingredients. The first is, I think all organizations need to find a way to make sure that they're having an open dialogue. Dialogue is so critical in this space. And I think that dialogue starts from the top. I think visible commitment from the leadership, whoever that leadership may be, is a critical component anywhere. Sometimes those leaders might need some coaching and help and advice. This is new for a lot of people, and it's, it is daunting. And people haven't been asked necessarily in their career to know about this. So I think the first thing is, again, that support for the leadership so they're comfortable. And then there's a bottoms up piece too. It's really critical that the grassroots, the people who are affected, are engaged in the conversation too. You need both. It can't be diktats from the top or statements of support without that engagement. So big, small, or medium-sized organization, dialogue, getting the discussion going, and making sure everybody's involved. I think those are the key, the absolutely key ingredients.
Great, thanks, Kate. And a final question we had was asking about if we now have all of these people working from home and the person gets injured, does the WSIB still have purview over that? Can they file a claim? The answer is yes. The WSIB, actually, you can look at the Q&A on their website. There will be a determination of whether or not the injury is work-related. So not every slip and fall at home will necessarily result in WSIB benefits, but it's a great question because I don't think ever we envisioned that there'd be this mass migration to people working from their kitchen tables or bedrooms or kids' rooms for so long and on so many different types of industries. So very good question. We're coming up to the top of the hour. I'm cognizant of people's time. And so I will wrap things up with a few closing remarks. First of all, a big thank you to our speakers and all of you who have attended, whether it be today or all of the seminars over the last 3 days. We really appreciate your continued participation and engagement. We've had a lot of great questions, and it gives us really good energy to get ready to plan the fall client seminar. So stay tuned for that. I want to remind people to subscribe to the blog and also our podcast, which is hosted by Allison Walsh, who's a partner in our Edmonton office. And the last thing I want to mention to you is two upcoming events. First, next week, June 25th, will be the 25th session that we've been holding for the COVID-19 pandemic series. We're wrapping things up for the summer, and then we'll start back again in September with a panel of senior in-house counsel. We have some great and diverse group of speakers from a variety of industries talking about what the risk looked like from their seat, the types of things that they were dealing with, how their job changed, and providing kind of some practical recollection of what it's been like to manage a workforce through this pandemic. I know that all of you are doing that, so I'm hopeful that you'll all tune in. So stay tuned for that. The last thing is summer is upon us, which means, and potentially a true summer, a double dose summer, you could say, a 2-dose summer. What we're going to be seeing for sure, I know all of our group will be looking forward to it, and many of our friends, is vacation. People are going to be taking time off. And what we've put together is a vacation toolkit for our clients. This is going to be a very comprehensive review of your employment standards obligations for vacation pay. Vacation is one of the most complicated areas that employers and HR and legal and compliance groups deal with. And this is designed to be a really helpful tool for you to navigate those issues. The other reason why we're doing it is, for as long as we've been practicing, I know there's always been an idea that Canadian class actions are not as prevalent as they are in the US. That is changing. And one of the areas is in failure to comply with employment standards obligations, and in particular vacation. And so we think it's important enough for us to have devoted the time to provide a really comprehensive tool. And so this will be available to our clients. If you are interested in getting it, please contact your Denton's lawyer, and we'll make sure we add you to the list. I've seen the drafts. I've obviously been involved in drafting it. I think it's a great tool. It's practical, and I think you'll get a lot of use out of it as you hopefully ensure that you are compliant, and if you're not, that you're able to take quick steps to fix it. So with that, a big thank you to everyone. The sun is shining. The webinar is now done. So go out and enjoy the rest of the day, and stay safe, and all the best to you and your families. Thank you again. Bye-bye.